Some really good comments on that most recent Tommy Robinson judicial review video I did. And a few people have asked some questions, and I keep seeing the same ones crop up. So what I thought I'd do is just take the opportunity just to answer those. So the first one, how many other people are in prison for contempt? Well, it's very common. About 10 people a month on average sort of get threatened or actually have a custodial sentence imposed for contempt. But a lot of these, they're just within the sort of hearing itself, where people are just like refusing disclosure or not making payments. So the judges will say, I will commit you for contempt, but I'll suspend that, or I'll give you a chance to purge your contempt if you put that right now. And most people do that because rather than just sort of walking down to the cells at the court, they suddenly remember that they can comply with those disclosure obligations, or they can make that payment. However, did check on this, and currently the most recent comment I got was from earlier this year in February, and at the time there were 9 people in custody for contempt of court. I mean, I see this quite a lot because I do all the animal rights stuff. And obviously you get a lot of injunctions to stop people protesting outside certain places, certain shops on Oxford Street that sell for vivisection laboratories, places that breed beagles for experimentation, that sort of thing. And obviously, and you've also seen with all the Just Stop Oil lot, where they get injunctions against them, sort of stopping them attending certain places, and they quite often breach those. So people do end up inside. It's not uncommon for people to end up inside for contempt. One interesting example I found, because people say, well, what about the sentence? It's quite lengthy. Well, yes, it is, but it's because there were sort of 10 breaches and he'd been given lots of warnings, and he continued to breach even after they'd said, we will do you for contempt. And we see this, like I say, you get this a lot with the animal rights stuff. If people go along and say, okay, I've learnt a lesson, I won't do it again, Governor, then usually the courts will let them get away with that. But if people say, no, I am going to stick by my principles, I don't care, injunct me all you want, I am still going to continue doing this, then obviously they get longer sentences. There is actually, though, the courts do recognise the idea of people breaking the law on principle. But there they say, the deal is, yes, you break the law, we accept that, and we sentence because of your conscience, but you have to accept, it's always been, if I am going to break the law because I think the law is unjust, that yes, but you still accept that you will get the punishment for it. That's the sort of, deal. But there's an interesting one, because it's a solicitor I actually know. He failed in some disclosure obligations, because he gave, he was requested to provide certain material and to explain, where certain monies had gone. He refused to do so. He got 14 months. I'll just point to there if I can remember to find a screenshot of that. I mean, actually, in the end, he ended up getting 12 years in prison because on the back of the failing to do the disclosure obligations, they just went after him for all sorts of offences. And, to encourage the others, I mean, people say, oh, the judiciary, they always stick up for lawyers. It's like, no, they don't. If they think we are bringing the system into disrepute, they give some right good kickings. People are asking, hang on, this is a civil offence, how come it's ended up with a criminal penalty? Well, let me explain. First of all, obviously we've got, criminal justice system and a civil justice system. You can have criminal cases and you can have civil cases. There's also criminal contempt and civil contempt. But that doesn't relate to the type of proceedings, it's the seriousness of the offence. So, you can be done for criminal contempt in civil proceedings. Actually, and you can also be done for civil contempt in criminal proceedings. It just depends how serious the contempt was. So say, for example, you do something to interfere with a civil trial, something that could disrail, that trial, then that will be taken very, very seriously. And although it's a civil case, and this is what happened in the Robinson case, it will be dealt with as a criminal contempt. But say, for instance, it's a criminal trial and one side or another is a bit late with some disclosure, or a witness turns up late or something like that, then again, that is a contempt. But if it's just something sort of technical, the courts will just treat that as a civil contempt. Also, how are contempts dealt with? Do you get a trial or does the judge deal with it? Well, again, it depends. And it's to do with whether it's just contempt generally, or what we call contempt in the face of the court. Excuse me, just a quick coffee. Because stop dry mouth, and also I'm stood outside where it's freezing. Okay, the rule is that if you commit a contempt, if it is in the face of the court, the judge can deal with it there and then. But what that means is that's something that needs to be addressed immediately, because it's risking derailing a trial or otherwise interfering with the course of justice. So say, for instance, somebody is being disruptive in the public gallery or something like that. Or somebody is outside a criminal trial putting forward stuff that isn't actually admissible in evidence. Because there the risk is to the trial immediately, the judge can say, right, I need to knock this on the head now. So the judge can deal with it themselves. You are entitled to representation and you are entitled to defend yourself, but they might say something like, right, I need you back here at 2 o'clock to explain why you shouldn't be sent down in the cells. Because if we don't do that, and you either promise not to do it again and you apologise and, quote, purge your contempt, you might get away with it. But if you're sort of basically clearly kicking off and they've had to get security to sort of, take you down to the cells, the judge will say, right, I need to keep you in the cells till the end of this trial, because otherwise you're going to keep disrupting it. If it was something, though, where it's not an immediate threat to the trial, somebody publishes the names of children, because generally speaking you're not supposed to identify children involved in legal proceedings, whether that's civil or criminal, but somebody publishes an article that identifies some children. For instance, in the Southport case, the surviving children, there is an order in place that they are not to be named. But let's say somebody does publish their names. Well, obviously that doesn't jeopardise any trial or anything like that, but it's still a contempt. But in that case, it's not, say, the trial judge who made the order who deals with you. You are just generally prosecuted. And to go back to Tommy Robinson, you may remember a couple of years ago, there was a thing there where he was done for contempt and the judge dealt with him. He appealed that, and his appeal was successful, because what he said is, what I did was outside of court, and yes, I did disclose some materials that, or even it was just basically just outside court telling people things, and it's like, well, no, this needs to be dealt with in court. But he said, the jury were given directions to ignore everything I'd said, and the trial went ahead and people were duly convicted. So I didn't actually interfere. It wasn't an immediate thing. It didn't need dealing with by the trial judge. It could have been dealt with later. And his appeal was successful. They said, yes, we will set aside your finding of contempt that was found by the trial judge, and we will say this should be listed in front, for a full hearing. Although, after that he was duly found to be in contempt again. But that's the distinctions, like I say. So you've got civil versus criminal contempt, but you can have criminal contempt in a civil case and civil contempt in a criminal case. And you have contempt, just general contempt, and then contempt in the face of the court, and that decides how you are dealt with, whether you are dealt with just by the trial judge in the middle of the proceedings, or if you are effectively prosecuted for contempt. Because it is a criminal offence. You are prosecuted for contempt and you effectively go on trial for that. Finally, what's his status in prison? Well, notwithstanding he was convicted of criminal contempt, people done for contempt, whether it's civil or criminal, they are counted as civil prisoners, because technically speaking, although you end up being sent to prison, it doesn't count as a conviction or a sentence of imprisonment. It's rather strange that, but it's the whole prison versus jail thing that we used to have, which we don't have now, because all jails are in prisons, but not all prisons contain jails. But you are regarded as a civil prisoner. And what does that mean? You have a few extra rights. For instance, you can wear your own clothing. And also in terms of the regime you're under for like visits and phone calls and things like that, because you heard that he was actually getting more than most people would do in terms of access. But the rule is, if you are a civil prisoner, you must get all the same benefits in terms of visitation and letter writing and phone calls and access to the internet as a remand prisoner would get in the same prison. It can't be low. They'll give you more than that, but they can't give you less than that. So you are treated the same way as somebody on remand, because effectively they are unconvicted people. So, there's less justification for restricting those people's liberty. But like I say, I think, go back and read the actual judgment, because a few people have said, well, hang on, why wasn't this said, didn't the court take this into account? The court just believed the prison. I mean, the problem for Mr. Robinson is his own counsel, on instructions from him, they didn't raise any of these points. They did not challenge what the prison was saying. They accepted, and yes, there were some issues about sometimes it didn't work, and even within the hearing, the phone link went down. But to be honest, that's completely completely usual. I mean, like I say, the parlous state of the criminal justice system. We rather use a thing called CVP, which I thought was Common Video Platform, but apparently it's Cloud Video Platform, and that's the video links between the prisons and the courts. And they go down all the time, either at individual courts, individual prisons, but last week it went down nationally. And because of the idea is that they tend not to produce prisoners live now, unless it's actually the trial. So if it's just like one of these preliminary hearings, or an application, you know, for something like an appeal, leave to appeal, or judicial review, they'll say we'll do it by video link. But the video links go down all the time. There's actually like a Twitter account that just gives a list of what's working in the court system, which courts are working. And if you look at that, you can just see it getting worse and worse. But there you go. So I hope that's answered all the questions. If not, please feel free to stick them in the comments to this video, and I will do my best to address them. But as always, hope you found that vaguely interesting, vaguely informative, and vaguely accurate. Thumbnail face.